Let me give you 2 or 3 highlights in that. One, lawmaker has changed the domain of filing a complaint. Now, the new law says complainant can file a complaint where he reside or work for gain. When I say reside or work for gain, means any migrant worker come to you. Suppose you are practicing in Mumbai and some North Indian from Uttar Pradesh, or could be Orissa guy, or could be Tamil Nadu guy, came for the treatment. He has got all the rights to file a case in Tamil Nadu, Uttar Pradesh, or could be in Orissa. So across the country, litigation are possible. I got latestly I got a case of Delhi where patient got treated in Delhi from Kerala, has filed a case in Kerala. Now doctor have to run from Delhi to Kerala to defend himself. So whole scenario got changed. Upper level of asking complaint and compensation has vanished because Honorable Supreme Court said that human body cannot be compensated by any amount of money. So upper level has gone. Even in the live patient, mental agony has been defined well under the Act. So mental agony means you need to be very careful because that is also a ground for asking a compensation. So earlier, to ask for 1 crore was difficult task for people. Now today, because that need to be justified. Now today, there's no justification needed because of multiple laws. So today people are filing cases in crores. I have got a case of simple injection abscess leading to septicemia and death of 30 crores, 28 crores, 30 crores cesarean death. So 5-10 crores are very common nowadays. Upper limit has gone. So you need to be very careful in dental practice. I have got a case up to the tune of 50 lakhs, 70 lakhs, 80 lakhs. Today with me where patient is alive. If patient would have died, it could be in crores. So multiplier method. This much year he is going to survive. This was the income of the guy. This much of probable income. This was the promotional income, same which was done in accidental cases. So scenario in a country got changed, my friend. So asking a compensation, upper limit has gone. So not to worry when you receive any notices of any crores or lakhs. You can be well defended in court of law and you can win the case if you follow few defenses, which I am going to share with you in the post completion of liability. So Consumer Protection Act has not only brought the compensation part and the filing complaint part, but also added to that is another chapter where advertisement has been very seriously governed under the Act. Now, advertisement means what? Today, being a social area, every doctor I found are promoting themselves either in print media or social media. Let it be your website, let it be your WhatsApp, Instagram, Facebook, or wherever you are presenting yourself, or through any media channel, print materials, visiting cards, leaflets, XYZ. This was not been very seriously taken earlier because medical council, that is dental council, used to govern this particular domain. But now, Consumer Protection Act has also added a chapter, and Consumer Protection Act says misleading advertisement, ambiguous advertisement, soliciting advertisement is actionable. And first penalty is 10 lakh rupees, my friend. Second penalty is 50 lakhs and followed by jail punishment. Sensodyne advertisement earlier and today his gross change, if you see, Sensodyne was punished for 10 lakh rupees. And not only that, out of 140 crore population, anyone can file. So your rival also can file on your social media presentation about your practice. So be careful what you write on that. Let me give you an example of ambiguity as per the court. There was a case where the cosmetic center has given an ad of up to 50% treatment benefit to the patient. The discount up to 50%. Cosmetic dentistry, patient has done the treatment, doctor has given just 20% discount. She went to the consumer fora and she said, I gone to this particular center with expectation of getting 50% discount because this was the ad. They mentioned up to 50%. But I have been cheated and deceived by the center and I was given just 20% discount. So it is deficiency service. Doctor has defended saying that up to means it is my purview to decide about 0 or 50. But court said, no, you are deceiving a consumer. When you write up to 50%, it need to be 50%, or you specifically mention 20% or 30%. and they said this is ambiguous advertisement, actionable. So my friend, you need to be very careful while putting anything on a board, because that can lead to very drastic compensative problem to you. Yes, Dental Council of India also become more active because lots of cases are going to Dental Council of India. Any tweet to PMO House, any tweet to any health ministry are getting diverted to Dental Council, and so moto action has been initiated against doctor. Many of the complaint is going to DCI. Online email complaint become easy today, even for the consumer forum and medical council. So cropping up lots of cases across the country. In such a scenario, my friend, even you need to defend yourself in the medical council, dental council. There, the punishment could be suspension of a medical registration, or it can be removed from the list. So you need to be very careful, because ethical practice, well defined under the law, need to be followed, which talks about all these things very clearly, categorically, which every doctor need to be know. My friend, when you know the criminal liability, civil liability, medical council liability, definitely it is important for all my practicing doctor to be aware about the defenses part of the same. How I can defend myself in such a scenario. I will definitely advise you, my friend, few of my experiences in a court of law, which you need to follow. That is my humble request, because that can really protect you a lot in today's era. In which first recommendation, I strongly recommend to all my doctor to maintain a medical record. If you're good in medical record, my friend, you are going to win the cases in every corner in the country, because your medical record is the only piece of evidence to save you. If you don't maintain a medical record properly, it can take you to jail also, or can be great compensation part. I said jail because the IPC general exclusion very category said that anything done with the consent of a patient for good faith, even if patient dies, no offense. But if you don't have a record of a consent prior to surgery and patient died, how and what defense you are going to talk there? So you need to maintain your medical record properly. Let it be consent form, let it be your continuation sheet, or it could be your summary of the treatment. Anything you write on a paper, is even the lab test, scan test, pre-investigation, fitness, everything counts under the due care part. So your medical record speaks very loudly about the due care. If you're given a due care, even in complication, you'll be safeguarded. Due care, like I'll give example. If you're given a history by the patient about hypertension, ISD, or elderly patient, or diabetes, take a fitness if you're going for any major surgeries on a patient. But fitness from appropriate doctor, the specialized doctor, who can take a responsibility of giving fitness, not by anyone. I know a case where my doctor was supposed to remove the tooth of 72-year-old guy who approached this dental surgeon, and naturally knowing that he need to have, because history was given by the patient about ISD and other thing, he recommended fitness certificate. And now he went to his own general practitioner, probably BMS doctor, who has just examined the BP and examined the vitals physically and given a fitness. And when tooth was extracted by this doctor, by evening, he get a call from the relative that patient died. And naturally, you can understand how painful scenario this doctor need to face. So fitness means you need to be taking a proper fitness. It's not in every case, but wherever patient is given a proper history, you need to definitely take care. Basic SGT, glucometer you can have in your clinic, PP instrument you can have in clinic, which can help you to at least basically help you to diagnose the thing on the spot. I know a doctor who has extracted the tooth. Patient went home, came back immediately with a profuse bleeding. He tried to give all packing, but could not able to. Again, patient came, bleeding was not stopped. Then he called his orthodontist friend at midnight around 10:30, 11 o'clock. When the doctor arrived, she asked for the BP instrument, and doctor was not having a BP instrument. I don't know, but in academic, you have been taught of taking BP. Then he rushed to neighbor clinic, brought a BP instrument. When it was examined, it was around 220, 160, high blood pressure. That could be the reason of profuse bleeding. Immediately, she asked for suture, but suture material was not there. Patient got admitted in the hospital where BP was controlled, and then suturing was done. And she filed the cases in every corner. So, my friend, basic vitals can be examined, which you taught an academic year in a clinic, which record you need to maintain. So that is a part and parcel of medical record. I'll just give a two example to make you understand with the judgments. There was a judgment not related to dental, but was a neurosurgeon who has posted a patient. I am giving because this can relate to your own practice. This doctor has given, called a patient for lumbar puncture. Patient died after 4 days because of brain hernia or some other complication. But during lumbar puncture, the procedure was done and relative has not allegated on a medical negligence, but relative said the deficiency is because of causing a severe pain. And he narrated the court when this procedure was done. I heard crying voice of my sister, painful voice of my sister. I rushed to procedure room. I found that two people were holding my sister and doctor was injecting something on her back. That was the LP procedure. Doctor is defended saying that I have followed standard protocol of treatment. I have given a local anesthesia prior to procedure. So there is no question that pain can arise. But when medical record was observed, it was utter surprise to all that nowhere local anesthesia or LA word was mentioned on the paper. And I have found multiple papers in country which came to me where procedure was done under LA by the dental surgeon have not mentioned LA word on their record. I don't know why. But even if it is routine, you need to write about the procedure under local anesthesia, little about the procedure. That is a part and parcel of medical record, which you need to be very careful because that case has gone against the doctor. It is deemed that LA was not given. Another case where this cosmetic department has received a patient for laser remover through hair remover through laser. Doctor has advised 10 sitting, 8 sitting. The laser has not affected well, so he increased the frequency, leaded to skin burn, which was got treated. Later, this lady has filed a case against the doctor, and doctor was able to defend himself with a consent paper and shown to the court the consent paper where he has mentioned in consent paper the possible complication of burn, which got treated, and said to the court that this was well explained to the patient prior to the procedure, and she has read it and signed it and got treated, was well accepted by the court of law, and they have relieved the doctor. So the medical record plays a vital role, my friend. If you make a good record, you can be safeguarded in this country for every single case, let it be criminal, civil, or could be medical concern. Second defense, very strongly I recommend, have a professional indemnity policy. As I said, you are protected by law, by judgment in a criminal case. But in civil case, when across the country cases are possible and going to get filed against you, you need to have some defense. And IDA has taken a pain for all their members. And IDA has tied up with the Doctors Risk Medical Legal Services and New India Assurance Company to provide you such a benefit in a very economical rate. So you need to have professional indemnity policy. Now, what is the professional indemnity policy? It is indemnifying the professionals for all the losses. So if at all any case get filed against you in any court of law and any compensation of suppose 50 lakhs been awarded, the insurance company will pay you 50 lakhs and all the damages, including the legal fees. So this policy is provided by New India Assurance Company. IDA has got this policy for you, which covers every aspect. The first policy ever in a country, which covers everything. What it covers? It covers 1:1. Means one case of 1 crore, suppose you got 1 crore policy, 10 case of 10 lakh, 5 lakh or 20 case, any number of cases, unlimited number of cases till the time amount get exhausted. So have a policy 1:1. Have a policy which covers complete legal fees across the country. As I said, anywhere in a country. So if advocate fees is covered, you can appoint any advocate in any part of the country. You do not have to worry about the payment, and then people are there to help. So covers already. It is a cashless, means if at all award is given by the court, insurance company directly pay to the claimant. You do not have to pay and ask for the reimbursement. This is having out of court settlement to save the reputation of doctor in indefensible cases. Probably insurance company may settle the matter directly with the patient. This comes with all latest technology coverage. It's the only policy in the country which covers all latest technology like laser, LASIK, or it could be second opinion, online consultation, robotic, everything has been covered, hair transplant, everything has been covered in this policy. And very, very importantly, openly, this covers all cosmetics. So dentistry are now 80 to 90% in the cosmetic domain. You need to have such a policy because it covers complete cosmetic domain, any cosmetic procedure. So there's no repudiation of the claim. So this is available to you all from IDA in a very economic rate. If you ask me, there could be rate not more than 500 rupees a month also. So if you're getting across the country advocate with paying 5,000, 6,000 or 7,000 a year, and even one case happen and your advocate fees is covered, believe me, my friend, this is one of the best deal which can be done. And I thank IDA for making such a policy for their members. Please do go for this without fail, because that will cover complete civil liability of yours. You need to very confident after having a policy. I have seen a people sharing their policy Xerox to the patient if at all any litigation happens, and openly says go and file the case. So that will build your confidence to avoid civil cases against you. I will advise the third defense, the medical legal expert. Today, I am there. Like me, many of the medical legal experts could be there in the country. Have them on a fingertip. For all IDA members, I am always there to protect them and defend them with my experiences. But why I say medical legal service? Because indemnity policy comes in a picture when case get registered against the doctor, and no doctor want to have a case against them. Seriously, because we are in the social media, any case get registered against you, become a public document, and it can be posted on a public domain. So if at all any case get registered against you, it will be posted on social media. And once it goes on social media, my friend, anyone types your name, the case will come and you lose a patient. So reputation loss cannot be compensated. So avoid a case against you. How you can avoid? With your medical legal service provider, like a doctor's risk, because they help you in pre-litigation. Pre-litigation means wherever patient is shouted or being potent litigant, you understand that, audit your medical record, because 72 hours you got to give the medical record. So audit your medical record with experts. What is written, what is not written, how, and because your medical record is only going to be the defense. Answer the notice in such a way that it does not go to the court of law. Support during pre-litigation to the doctor with their expertise. So Dr. Risk Medical Legal Services does this for 18,000 cases, not even single case has gone to the court of law. And that is the great success of medical legal service, my friend. Second, during litigation or during the procedure, if any onset has happened, any complication happened, including the death, call your medical legal service provider. Technology platforms are there to share all medical record. They will guide you what next to be done, how and what way media can be taken care of, how mob can be taken care of, how importantly, if needed, advocate can help you at that particular given scenario situation. Everything is covered under the domain of during litigation.